stranger to contract cannot sue. This is discussed under the doctrine of privity of contract, suit by third party. Today we are going to discuss one very important concept, that is stranger to contract and its exceptions. There are certain exceptional cases where stranger can sue. Very important for exam. This can be asked either as a theory question or case-based question. So case-based question can be asked on any concept, but we need to know the concepts on which theory question is asked. So this is very important for theory question also. But you cannot just write the theory and state the exceptions as it is. You need to first give some background. So let us also understand the concept so that you can write something about stranger to contract and then start explaining exceptions to the same. Suit by third party, that is, can third party file a case? No, stranger to contract cannot sue. We had discussed the example in my earlier lecture that A and B have entered into a contract. A can sue B, B can sue A. Third person, stranger, cannot sue. Stranger to contract cannot sue. He cannot sue even if the contract is for his benefit. See, he doesn't have a contract with either A or B. So on what basis will he file a case? When you don't have a contract, then on what basis will you file a case? So stranger to contract cannot sue. Okay. According to the doctrine of privity of contract. Now you must be wondering the meaning of doctrine. Yes? What is the meaning of the word doctrine? It's also known as doctrine. Sometimes it is pronounced that way. Now, this is not a provision in the Bare Act. Okay, you won't find the doctrine of privity of contract if you search the Indian Contract Act. But this is nothing but a judgment which is used by many other judges. Now, let's say that there was no provision. So a judge gave a landmark judgment, okay? He applied logic, facts of the case, etc. and he gave a landmark judgment. Now that judgment was used by the other judges also while deciding their case. So when we give reference to, see, the judge of the High Court or the judgment that was given in this case law, we apply that same. So when that judgment started being used by many other judges also, it became a generally accepted practice. Now that generally accepted rule is nothing but a doctrine. So you have the doctrine of caveat emptor, you have the doctrine of indoor management, the doctrine of constructive notice. All this we are going to study later in the Companies Act also and Sale of Goods Act. So the doctrine is basically a judgment which has been followed by many judges subsequently. So that became a generally accepted rule. It is nothing but a doctrine. So the doctrine of privity of contract says that when two persons enter into an agreement, only they have the right to sue each other. So only the parties to the contract can sue each other. A stranger, third person, cannot sue. The stranger over here doesn't mean the person that we don't know, that kind of stranger. Here, stranger means third party. Stranger to contract cannot sue. Let us discuss these examples. I will write it separately for you, okay? You need not copy. This is already given to you in the textbook. But I will discuss it as I write. Now, let's say that X gave loan to Y and Y gave that same amount as loan to Z. Y told Z that please repay the amount on time, okay? If you don't repay, then I will not be able to repay the money to X and he will file a case against me. So please pay the money on time. Now Z defaulted. Okay, he did not pay the money on time. Z defaulted. Y was not able to repay his loan to X. Now X wants to file a case against Z. Can he file a case? How many contracts are involved? Tell me. How many agreements are involved? Two. One is between X and Y, and the other is between Y and Z. If Z is not repaying the loan, who can file a case? Y. Y can file a case against Z. X cannot file a case against Z because X is stranger to contract between Y and Z. So Y will file case against Z, and if Y is not repaying, then X will file case against Y. X cannot sue Z because X is a stranger to contract between Y and Z. Another example. A had to pay 25 lakh rupees to B, but he doesn't have money. So he sold his house to Z. Okay, he sold his house to Z. Now Z asked him, what are you going to do with this 25 lakh rupees? He said, I need to repay the money to B. Who? B? Are he lives nearby. You don't worry, I will hand over this money to him. See, it doesn't make sense now that you carry all this money and then give it to B. Anyways, B stays near my house, I will give it to him. So Z promises to pay the money to B. But he fails. Z fails to pay money to B. B wants to file a case against Z. Can B sue Z? How many agreements are involved? Two. One is between Z and A. Other is between A and B. If Z defaults, who can sue Z? A. B cannot file case against Z because B is stranger to contract between Z and A. So he cannot sue because he is stranger to contract between Z and A. The contract is between Z and A. If Z defaults, A can sue Z. B cannot sue Z because B is stranger to contract. Let me give you a variation. A had to pay money to B. He doesn't have money, so he sold his house to Z. Z promised to pay, and then he fails. This was our example. Now let me give you a variation. Z calls up B and he gives acknowledgement. Z calls up B and he says, Arey B, listen, I am holding that 25 lakhs for you. Whenever you reach home, just call me. I will come and give that money to you. As soon as Z gives acknowledgement to B, Z is considered as if he is agent of B. See, B has never appointed Z as his agent, but we consider as if Z is agent of B. So this sign means similar. Okay, the sign means he's similar to an agent. He's treated just like an agent of B. Now, what if Z defaults in this case? He fails to pay the money to B. Can B file case against Z? Yes, because we can file case against our agent. So here, can B sue Z in this case? Yes, as B can sue his agent and recover money. Yes, I agree. We had not expressly appointed Z as an agent, but because Z gave acknowledgement, he is considered as agent by acknowledgement or agent by atonement. Okay, that all those words are not very important for you. Just remember that he is considered as if he is the agent of B, and as an agent he can be sued. So here if Z gives acknowledgement, then yes, we can sue Z. Did you write all this? This you need not write. Here, acknowledgement part you can write. Okay, done. Very good. Both the examples are discussed over here. Same example. Yes. And I also gave you a variation wherein if acknowledgement is given, then yes, we can file a case. Very interesting case law, Dunlop Pneumatic Tires versus Selfridge. You need to learn the name of this case law. Dunlop Pneumatic Tires versus Selfridge. Why is the name important? Because in case a question is asked on stranger to contract, then you are expected to write the name of this case law. So you need to know the name. Now Dunlop was a manufacturer of tires. Okay, so let's discuss it from the arrow format. Dunlop was the manufacturer of tires. It entered into an agreement with various dealers, one of whom was Dew and Company. So Dunlop entered into an agreement with various dealers, one of whom was Dew. He said that you will not sell tires at below the recommended retail price. See, they wanted to maintain a particular price level. So they said you will not sell each tire for less than 10,000 rupees. We want to maintain that price level. I don't want that there should be a price war. All my dealers will sell the tires at minimum 10,000 rupees. You can sell at 12,000 also. You can sell for 13,000, but you will never go below 10,000. I don't want that, Arey, that dealer is giving for 10,000, I'll give it to you for 9,000. I don't want you to do that because then there is no end. So we want to maintain a price level that our tires will not be given below 10,000. So they entered into an agreement with various dealers that you will not sell tires at below the recommended retail price. Enter into a similar agreement with your retailers. So Dunlop instructed all their dealers to enter into a similar arrangement with their retailers. Dunlop entered into an agreement with the dealers not to sell the tires at below the recommended retail price. They asked all the dealers to enter a similar undertaking with their retailers. So Dew entered into an agreement with various retailers, one of whom was Selfridge. So what is our hierarchy? Dunlop was the manufacturer. It entered into an agreement with Dew and Company, the dealer, and Dew and Company entered into an agreement with Selfridge, who is the retailer. Did you understand the hierarchy now? So Dunlop entered into an agreement with Dew, and Dew entered into an agreement with Selfridge. He said that don't sell tires at below the recommended retail price. If you do, you will have to pay £5 per tire as damages to Dunlop. So Dew conveyed this message to various retailers that if you sell the tires at below the recommended retail price, you will have to pay damages of £5 per tire to Dunlop. Now Selfridge sold few tires at below the recommended retail price. Dunlop filed a case for recovery of damages from Selfridge. Can Dunlop sue Selfridge? How many agreements are involved here? Two. The first agreement is between, tell me, Dunlop and Dew, Dew and Selfridge. In case Selfridge sold few tires at below the recommended retail price, who can file case against Selfridge? Due. Can Dunlop sue Selfridge? No. Dunlop is very good, students. Dunlop is stranger to contract, and stranger to contract cannot sue. So can Dunlop sue Selfridge? No. But ma'am, it was clearly written that in case Selfridge did not sell tires at above the retail price, then Selfridge will have to pay damages of £5 to Dunlop. So can't Dunlop file a case on these grounds? See, it was already mentioned, no, that you will have to pay damages to Dunlop. That was only an information given to Selfridge that listen, if you sell tires at below the recommended retail price, you will have to pay damages. And that was conveyed through due. So due had entered into an agreement with Selfridge. If anything goes wrong, you will file case against Selfridge. He was just informing Selfridge that I am not going to keep these damages. I am only going to collect them on behalf of Dunlop. I am not going to keep anything for myself. So he just wanted to convey that these damages are to be given to Dunlop. So in this case, Dunlop is a stranger to contract. He cannot sue. And we have one more doubt. Can Dunlop be stranger to consideration over here? You are saying that he's stranger to contract, but can he be stranger to consideration over here because he's going to get those £5 per tire? My dear students, what is the consideration in this case? Is it those damages or is it the sale price of the tires? Tires, right? Sale price. So, is the case law regarding the sale price of the tires or is it relating to damages? Damages. So, here the consideration is the sale price of the tires. That is not our area of discussion. We are discussing about damages. Okay. Also, we had discussed that A was an old lady. She, by a gift deed, transferred property in the name of daughter R. Ramaya. So there was some consideration. Out of this consideration, R promised to pay something to C. Chinaya. Is that over here? Is some consideration given, and from that consideration you are agreeing to give it to someone else, you are agreeing to pass it on? That's not the case. So please don't be under the impression that Dunlop is stranger to consideration. There is no fact which points us in that direction. Okay. Also, the actual case law, if you read, it also tried to find out some kind of agency relationship, principal agency relationship. So can we consider that Due is agent of Dunlop, and on that grounds Dunlop as a principal can file a case against Selfridge? They tried to find out agency relationship, but there was nothing to show that Due acted as an agent of Dunlop. See, if Due was the agent of Dunlop, then Dunlop as a principal could file a case against Selfridge. But there was nothing to indicate that there is some kind of agency relation. So that was also ruled out. The only reason which remained valid was that Dunlop is stranger to contract and stranger to contract cannot sue. So Dunlop was not the right person to file a case against Selfridge. Due was the right person to sue Selfridge for the damages. So Due in this case will file a case against Selfridge, recover the damages, and then pass on that damage to Dunlop. Ma'am, what if Due fails to pay the damage to Dunlop? Can then Dunlop file case against Due? Yes, we can file a case and recover the damages which he collected. So students, I have given you various possibilities. These may be the different doubts that you had in your mind. If you did not think of any of those points, forget it, don't worry. The only valid reason which remains here is Dunlop is stranger to contract and stranger to contract cannot. So these are the facts. I would like to discuss one extra point with you. If you have finished going through the case Then let's discuss that extra point. Did you notice that these 5 pounds per tire, okay, they have already been decided at the time of contract? Yes. Now, these are pre-estimated damages, also known as liquidated damages. Let me write it over here for you. These 5 pounds per tire, we decided in advance. If anything goes wrong, Selfridge, you will pay 5 pounds per tire. This is pre-estimated. Nothing has gone wrong. We don't even know what is the actual damage, but we have already decided that you will pay 5 pounds per tire. These pre-estimated damages are also known as, AKA means also known as, liquidated damages. Okay, so what is the proper word for that? These pre-estimated damages are also known as liquidated damages. Now, liquidated damages or pre-estimated damages, they are already decided in advance. Even before there is some kind of breach or some kind of wrongdoing like in this case, Selfridge sold tires at below the recommended retail price. So if you do that, you will have to pay 5 pounds per tire. So they may decide any amount. You will have to pay 5 pounds per tire. You may have to pay 5,000 rupees per tire. You may have to pay 50,000 rupees lump sum. Any kind of pre-estimated damages are known as liquidated damages. The word breach which I used, I will be discussing that in detail in Unit 5. There is an entire chapter on breach of contract. But over here, if you just want to write the basic meaning of breach of contract, then you can mention when parties fail or refuse to perform their promise, then it amounts to breach of contract. So here X promised to supply goods to Y, and Y promised to pay him 1 lakh rupees. X refuses to supply the goods. This amounts to breach of contract. The aggrieved party, Y, okay, Y also known as the aggrieved party. The aggrieved party can claim damages. So breach means when one party either fails or refuses to perform his promise, then that amounts to breach of contract. The aggrieved party can claim damages. So these damages we are going to study when we study breach of contract. Liquidated damage is a kind of damage. These are pre-estimated damages. They are already decided. Even before the party fails or refuses, even before breach, they are already decided. If there is breach, you will have to pay 5 pounds per tire. These pre-estimated damages are also known as liquidated damages. I hope you finished writing all this. Yes. Let us discuss now. So these are pre-estimated damages. We already discussed the difference between stranger to contract and stranger to consideration. Yes, we already discussed this last time. Stranger to contract and stranger to consideration. Now, there is one very beautiful example given over here. I would like to discuss that with you. A's father. Yes, I agree. I had already discussed that earlier, but I would like to revisit it. A's father and A's father-in-law. Okay, A's father and father-in-law both decided to contribute rupees 50,000 each. Is it 50,000 or 1 lakh? Okay, some money. So they decided to contribute 50,000 rupees each and give it to A at the time of his marriage. Father contributed, but father-in-law did not contribute. Now, can A, can A sue his father-in-law? Can he sue his father-in-law? Now, the contract is between A's father and father-in-law. Okay, there's a contract that we will contribute 50,000 rupees each and give it to A at the time of his marriage. The contract is between A's father and his father-in-law. So if father-in-law is not contributing, who can file a case? A's father can file a case. Okay, the party to the contract can file a case. Can A file a case? No, because A is stranger to contract. Oh, battery. Pencil is discharged. So can A file case against his father-in-law? A cannot file a case because A is stranger to contract, and stranger to contract cannot sue. He cannot sue even if the contract is for his benefit. He cannot sue even if the contract is for his benefit. So can stranger to contract sue? No. Stranger to see, here he was going to receive the benefit. He was going to receive 50,000 from his father and 50,000 from his father-in-law. Yes. So even though the contract was for his benefit, he still cannot file a case because he is a stranger to contract. If father-in-law is not contributing, father will file a case because there is a contract between these two parties, and only the parties to the contract can sue each other. But yes, I totally agree that there are certain exceptions, and under only those exceptional cases, stranger to contract can sue. Ma'am, how will we understand in the exam that it is an exception? The headings will help you, students. The head points will help you. So if in the question you find creation of trust, you find family settlement, you find marriage contracts, so this will give you a hint that it is talking about exception. We had also discussed the difference between stranger to contract and stranger to consideration. I had given you the difference between, so I'm not discussing that again. Stranger to contract and stranger to consideration, this is one point of difference that we can discuss, although it is not important for exam. Stranger to consideration can sue in India but not in England. But stranger to contract can sue neither in India nor in England. Okay. So stranger to consideration can sue in India but cannot sue in England. However, stranger to contract can sue neither in India nor England. Alright, just a point of difference. We just want to prove that we have not copied the English law. That's it. Okay. Now, stranger to contract cannot sue. Yes, we agree, but there are certain exceptions. Under these exceptional cases, stranger to contract can sue. Okay. In case of a trust, A transferred his property to B to be held in trust for C. Okay. A transferred property to B to be held by him in trust for C. Now let's create a story behind this. A is a grandfather. A is a grandfather. He is very old. He wants to give 5 lakh rupees to his grandson. He wants to give 5 lakh, but he says, I don't want my grandson to have 5 lakh rupees before he turns 21. Now, son is actually 15 years old. The grandfather, what he does, he transferred. See, property here does not always mean immovable property. Property means anything belonging to the other person. So he gives 5 lakh rupees to B and tells him that you hold it in trust for my grandson. Give this money to him when he turns 21. Mera kya bharosa? I am there today. I may not be there tomorrow. But I want my grandson to have this 5 lakh rupees. So you hold it in trust for me. So A gave 5 lakh rupees to B to be held by him in trust for C. Okay, so keep it for C. Give it to him when he turns 21. Now in this case, what if something happens to the grandfather? Dad. B is refusing to give that money to C when he turned 21. Can C file case against B? Can C sue B? This is my question. Ma'am, we are studying exceptions. Of course, he can file a case, but what is the logic? Now, see, ideally speaking, there is a contract between A and B. Okay, there was a contract between A and B. C, if you see technically, he is a stranger. So ideally, he cannot file a case. But because a trust was created, okay, because a trust was created, he is the beneficiary of that trust. Beneficiary, even though he is a stranger to contract, beneficiary can sue. Okay, so in this case, C can enforce the contract even though he was not a party to the agreement of trust. Here, the beneficiary of the trust can sue. Ma'am, just a minute. You gave us one example of father and father-in-law, right? In that case, A was also the beneficiary. He was going to receive the benefit of 50,000 from his father and father-in-law. Here also he was the beneficiary. Why did you say that here he cannot sue? Was a trust created? Was it a trust? No. So this is not an exception. So did you understand now? Yes. So in this case, I agree, even though the contract was for his benefit, but trust was not created. So this is not an exception. See, this is how we keep relating, one example with the other. And this is how I feel I am able to solve all your doubts. Yes, even though it is a recorded lecture, but I'm very sure that these are the few points which you keep thinking, ma'am, what if this, what if that happens? And if I'm able to address that in the lecture itself, you will gain immense concept clarity in these lectures itself. So there was a contract between A and B. A trust was created. C was the beneficiary of that trust. Beneficiary of a trust can sue. In case of family settlement. Now, I'll give you one other example and then we will discuss the example which is given in your textbook. Okay, this is a different example. Now, it is a hypothetical example. It is not based on true facts. Okay, just an imaginary example. Mukesh and Anil, they decided to partition their business. But at the time of partition, they agreed to contribute certain money for the maintenance of their mother. Okay? So they were in the process. This is hypothetical example. So Anil and Mukesh, they decided to partition their business. But they decided that at the time of partition, each of us will contribute some money for the maintenance of our mother. At the time of partition, both avoided to contribute. Can mother sue her sons? Mother is stranger, but because this is a case of family settlement, okay, they decided to partition their business. They decided that yes, we will contribute some money for the maintenance of our mother. Since this is a family settlement, the promises, the agreements made at the time of family settlements, they are enforceable. The only requirement is that they should be in writing so that there is a proof that such agreement was made. So in this case, Mukesh and Anil, they entered into a contract, let me say it is in writing, promising to contribute some money for their mother. Later, they refused to contribute Mother, even though she is a stranger, she can file a case because the contract was for her benefit. So the beneficiary in case of family settlement can sue provided the settlement was in writing. That is the requirement of law. When the disputes are settled by mutual agreement, so they mutually decided that you take half the companies, I will take half of the companies. When the family settlement is by mutual agreement and the terms of settlement are in writing, this is very important that the agreement has to be in writing, okay? Then such agreements can be enforced by members who were not originally parties to the settlement. So even though mother was not a party to the settlement, she can file a case. What is family settlement? When the disputes are settled by mutual agreement. So these are the key words. The settlement is by mutual agreement. There is no court case. They are mutually deciding how they will settle. The terms are reduced to writing. These are the key words. The terms of settlement are in writing. Then the document is known as family settlement. Such contracts can be enforced by members who were not originally party to the settlement. It means stranger can sue. Now let us discuss the example which is given in your textbook. Daughter and husband, they entered into a contract with father that dad, you don't worry. You transfer all your property to us. We will maintain the mother. Okay, we will contribute some money for the maintenance of mother. So they agreed to maintain the mother, and the father on this condition transferred the property in their name. Later they refused. Can mother file a case? The contract was between daughter, husband and father. Ideally, father should file a case. But because this is a case of family settlement, we are assuming it is in writing. Mother, even though she is a stranger, but because it is family settlement, she can sue. But this should be given in your exam that it is a case of family settlement. Okay, so even though mother was a stranger, she was entitled to file a case. In case of certain marriage contracts or arrangements, okay, in case of certain marriage contract, or maybe there is some kind of an arrangement in the case of, let's say, partition of HUF. Now, have you ever heard of the concept of Hindu undivided family, HUF? Yes. Now, at the time of partition, mostly it is the male members. Okay, female members as such don't have rights. Now, the male members of the HUF, they decided that we will keep some money for the marriage of female members. Okay, marriage of few female members. Education of minor. Or medical or some other maintenance expenses for the elderly. So they have decided that we will keep some money aside, and rest they divided between their families. Now the contract deciding all this was between the male members. Female member or that minor or that elderly person, actually they are stranger. If they do not get the promised money, they can file a case. It's an exception. At the time of partition of the property of joint family, the male members agree. So agreement is actually between the male members. They agree that certain portion of the property will be kept aside. Let's say, for example, maintenance of the elderly person, education of minor children, marriage of a female. The person for whose the benefit, this is important for us, the person for whose benefit the provision is made under family settlement, that person can enforce the contract. That person can file a case, can sue. Okay, so the person for whose benefit the provision is made can sue. So even though these people are strangers, Because the contract was for their benefit and the contract is an arrangement, it is a marriage contract at the time of partition of HUF. This is an exception. Although they are strangers, stranger can sue. Stranger can sue in this case. It's an exception. They will give you a hint. What is the hint that you will find in the question? Partition of joint family. You will find the hint marriage arrangement, marriage contract, or some arrangement at the time of partition. These kind of hints will be given to you in the question. Let us discuss another exception, assignment of contract, right? And the meaning of assignment means to transfer. Assignment means to transfer. X entered into a contract with an insurance company. He purchased an insurance policy. He paid premium and he purchased an insurance policy. He wanted loan, so he went to the bank. He said, bank, I want loan. Bank said, all right, you give me security and I will give you loan. X says, I have an insurance policy. If you surrender that policy on the basis of the premiums that I have paid, you will get some value. On that value, you give me loan. Bank agreed. X assigned, he transferred the benefit. He assigned the insurance policy to the bank. And on the basis of this insurance policy, bank gave him loan. What will happen if X fails to repay the loan? What will happen? The bank will file a case against the insurance company and recover that money. They will surrender the policy and get the money. The contract for that insurance is between X and the insurance company. Bank is a stranger. But because the benefit has been assigned to him, he becomes the assignee. And assignee can sue. It's an exception. Let's discuss the example once again. X purchased an insurance policy. He paid premium, got the insurance policy. He wanted loan, so he assigned this insurance policy to the bank and obtained loan. What if the bank does not get his money back? So they can surrender the policy and claim the money from the insurance company. So if X fails to repay, the bank can surrender the policy and recover their money. The contract for this insurance policy is between X and the insurance company. Bank is a stranger, but because the benefit is assigned to him, see, you have to assign means you have to give the insurance papers, you have to sign that assignment form, you have to tell the bank that, see, I am taking loan against this policy. If I fail to repay the loan, you surrender the policy, keep the money. So you are assigning the benefit. Bank is the assignee. Assignee can sue. Assignee can sue. So assignee, even though he's a stranger, he can sue because the benefit is assigned to him. When the benefit under the contract has been assigned, assignee can enforce the contract. Even though he's a stranger, he can enforce the contract. Same example. Official assignee of insolvent. Okay. Now, can I declare myself to be insolvent? Listen, everyone, from tomorrow I am insolvent. No. I need to apply to the court. The court will judge me as an insolvent. As soon as the person is judged insolvent, all his property is given to the official receiver or assignee. Now, this official receiver or assignee is actually a person appointed by the court. What does he do? He will sell the assets and try to pay off the liabilities. Now, let's say that X is declared insolvent. We will not allow his property to remain with him, otherwise he will run away with that property and never repay his debts. He's insolvent. So as soon as he's declared insolvent, his property is assigned to the official receiver or assignee. Now he will sell the assets and he will pay off the liability. Assets will also include recovery from debtors. What if debtors don't pay? Official receiver will recover money from them. But the contract was between X and that debtor. Assignee is actually a stranger. But here, because he has been given that responsibility, assignee can sue. He can sue. Estoppel by acknowledgement of liability or part performance error. Students, if you feel that ma'am, it is becoming too much for us, we cannot take it anymore, take 5 minutes break. You take 5 minutes break. But I'm going very slow. I can't go more slow than this. Okay. Have you ever come across the word estoppel? Oh, you must have studied in 12th standard partner by estoppel. Yes. Is he an actual partner? He's considered just like a partner. Okay, he's partner by estoppel. Now, X, Y, Z, they are partners. They have recently appointed M as a manager, very smart fellow. One day, X and M go for a meeting with supplier S. Okay, X and M go for a meeting with supplier S. X introduces M. He is M, our partner. M is very happy. I am a manager. But X introduced me as a partner. He's very happy. He doesn't correct X. Okay, he just plays along. Okay, yeah, I'm a partner. All right. M starts talking and he was a very smart person. S is very impressed. Wow, what personality. We should do business with him. S agrees to give goods on credit, thinking that M is a partner. What if X and the partnership firm fails to pay money? Can S sue M and make him responsible as a partner? See, M was not actually a partner, but he allowed himself to be represented as a partner. He is considered as partner by estoppel. He is estopped, means he is stopped from denying that I am not a partner. He is estopped. It means he is stopped from denying that he is a partner. You cannot deny. You will be considered as a partner. He is considered as partner by estoppel. Estoppel means you are stopped. Will he become a permanent partner? No. For this transaction, he is considered as a partner. So that is the meaning of estoppel. You're not actually a partner. You're not actually an agent. You're considered just like an agent. You're considered just like a partner, just for that transaction. Now in this case, Y had to pay some money to Z. So he gives 1,000 rupees to X. Arey, you are going that side, na? Just hand over the money to Z, na? I had to pay him 1,000 rupees. So Y gives X 1,000 rupees to be given to Z for some past debt or something. X Acknowledges. Arey, listen, Z. Listen, Z, Y has given money. You let me know whenever you come home, I will hand over the money to you. We discussed this earlier. हम जिसे acknowledgement देते हैं, हम उसके agent बन जाते हैं. So the person to whom we have given this acknowledgement, okay, we are considered as his agent. So he is considered as agent of Z. Yes. Y gives acknowledgement. Arey, listen, I am holding the money for you. The person who gives acknowledgement is considered as the agent. So X is considered as agent of Z. And can we file case against our agent? Yes. So what if X fails to pay the money? Now the contract is between Y and Z. See, Y had to pay some money to Z. So the contract is between Y and Z. X actually is a stranger. But because X had given acknowledgement, can I say because of this acknowledgement, X is considered as agent of Z? What if X fails to pay money? Can X sue Z? Sorry, can Z sue X? Yes. Ma'am, we have always studied that stranger can sue. Arey, it's not a one-way street, no? If stranger can sue, stranger can also be sued. So it's not a one-way street where only stranger will sue. Stranger can also be sued. So can Z file case against X? Yeah. Because X is considered as if he is the agent of Z. Okay, so he gave acknowledgement. He is considered as agent of Z. And Z can sue his agent. So in this case, if X fails to pay money, Z can file a case. Even though X was a stranger, we can file a case against him. Let's do it once again. Yes, once again you want to go through the example? Yes. Okay. Why had to, you tell me. Okay, now you mentally think of what I'm going to what I'm asking you, think of the answer. Why had to pay some money to Z? So what does he do? He gives that money to X. Y had to pay money to Z. It means that there was a contract between Y and Z. But he gave the money to X, third person, stranger. However, X gave acknowledgement to Z. He said, Z, I'm holding the money for you. As soon as X gives acknowledgement, he is considered as agent of Z. What if X fails to pay this money to Z? Can Z sue X? Yes, Z can sue X because because X is agent of Z and we can file a case against our agent. So yes, Z can sue X because X is acting as agent of Z. Is he actually an agent? Did we actually appoint X as an agent? He is agent by estoppel. He's not actually our agent, but because he gave acknowledgement, he's considered just like our agent. He is agent by estoppel. Okay, he is considered as agent by estoppel. He's considered as if he is our agent. He's agent by estoppel. Okay. The last one is covenant running with land. Now, these covenants are nothing but conditions attached to the use of land, or they are just basically conditions. Okay, land is just one of the exceptions. The basic meaning of covenant, it means that they are conditions. Okay, the meaning of the word covenant is condition. This is a covenant, it means it's a condition, it's just a condition. Covenants running with land, this is just one of the examples which we can consider for stranger to contract. So covenant basically refers to the condition. Because we are discussing covenants running with land, so these are conditions tied to the use of land. So covenants running with land, this is just one of the exceptions that we are studying. Now X and Y, they are two farmers. They own adjoining pieces of land. Okay, they own land which is like joint, adjacent. Now they have decided that we will never use the land for commercial purpose. We will only use it for agricultural purpose. This is a condition tied to the use of land, that it is going to be used only for agriculture. This is a covenant. A owns a piece of land which has a restriction that it will be used for church purpose only. This land will be used for church purpose only. So conditions which are tied to the use of land, they are covenants. See, covenant means condition. We are studying covenants which are attached to land. So this land will be used for church purpose only. This land will be used for agriculture only, never for commercial purpose. Now I have also introduced one extra concept of positive and negative covenant. Positive means to do something. Negative means not to do something. This land will be used for church purpose only, to do something. This is a positive covenant. This land will never be used for commercial purpose. We will only use it for agriculture. It will never be used for commercial. This is a negative covenant. Okay. So covenant means conditions tied to the use of land. These conditions are always attached to the land. The land is always burdened with these covenants. If we sell the land further, the land will go along with the covenants. So these covenants are permanently attached to that land. These conditions, they run with the land. Okay, they run with the land means if I sell the land will go with covenants. Okay, so the covenants will also go with the land. The land is always attached. They are burdened with the covenants. These covenants are binding upon current as well as future owners. Even though the future owners never entered into a contract creating those covenants, they will have to still abide by the covenants. And what does it mean? It simply means that X and Y, they entered into a contract creating the covenants. We will never use the land for commercial purpose. We will only use it for agriculture. They created the covenant. X then sold the land to Z. Z bought the land. It means he bought the covenants also. He will also have to use the land for agriculture only. He can never use it for commercial purpose. So the land comes with the covenant. The land is burdened with the covenant. They are binding not only on the current but also future owners. Although the future owner never entered into a contract creating the covenant, but he will still have to follow those covenants. So these conditions, they are binding on current as well as future owners. The covenant runs with the land. It means that although the new owner did not enter into a condition, it did not enter into a contract accepting the covenant, but he is still bound to follow. Follow means abide. Abide means follow. Even though the future owner never entered into a contract creating those covenant, but he still bound to follow those covenants. X and Y, they agree that we will never use the land for commercial purpose. We will only use it for agriculture. X then sold his land to Z. Later, Y started using the land for commercial purpose. Can Z file a case? Let's analyze. The agreement was between X and Y that we will never use it for commercial purpose. Agreement was between X and Y. Z is a stranger. But because he purchased the land along with the covenants, he is bound by the covenants. He can enforce those covenants. He can file a case if those covenants are not followed. Even though he is a stranger, he can file a case, can sue. Because he is also following those covenants. He can enforce those covenants. Even though the agreement was between X and Y, if Y fails to follow those conditions, then even though he is a stranger, he can sue. Even though Z is a stranger to the contract between X and Y, he can sue Y as covenants are binding upon current as well as future owners, because he is also bound by the covenants. He can even file a case if the covenants are not followed. He can enforce the covenants. So yes, even though he's a stranger, he can sue. Ma'am, what if Z is not following the covenant? Can Y sue? Yes, of course, Y can also file a case. So, stranger can sue, stranger can be sued. Okay. Is it possible, ma'am, that later Z and Y, they enter into an agreement that we don't want this covenant? They may enter into an agreement later. So, if they can impose the condition, they can by mutual agreement remove that also. But it depends like what kind of land it is. Sometimes government imposes that condition. So then they cannot mutually remove it. It's like government says this is agricultural land. It will always be used for agriculture. Contracts made by agent. Does agent enter into a contract for himself or is it for the principal? Ma'am, principal. So principal has appointed an agent. Agent is entering into contract with the third party. Let's say that X appointed Y as agent. Agent entered into a contract to sell goods to P. No, not P. Let's say A. So agent contracts to sell goods to Q, third party. Agent sold the goods, but Q is not paying money. Can the principal sue the third party? Actually, principal is a stranger, no? Contract is between agent and the third party. But is the agent entering into contract for himself? No. Agent is entering into contract for the principal. So actually, it is the contract between principal and third party. Yes? Agent is just a connecting link. The name in the contract will be of principal and third party. So on these basis, principal can sue the third party. Yes? Agent is just a connecting link. Agent enters into a contract for the principal. So the principal, even though he appears to be a stranger, he can enforce the contract entered by the agent. Principal can enforce the contract entered by agent where the agent has acted within the scope of authority and in the name of principal. So agent should have the authority to enter into that contract and he should enter it in the name of the principal. I know what you are thinking. Ma'am, what if agent did not have the authority? Or what if agent entered into a contract in his own name? Then you tell me, agent did not have the authority. Or agent entered into contract in agent's own name. Then who will be responsible for that contract? Agent himself will be responsible, no? Yes, in that case, agent will be responsible and he will file a case against the third party. But here, principal can sue because the contract is in his name, it is for him. So he can, even though he's a stranger, he can enforce the contract. Just extra information, if agent is entering into contract in his name, it is like his personal contract. So he will be held responsible to the third part. Okay. We will discuss all that when we come to the topic agency. A lot of discussion is pending. You have the entire Contract Act. So we will be discussing the concept of agency also. Okay. Okay, why with this we come to an end of this concept, stranger to contract. See, students, sometimes you may find that this concept is very lengthy, difficult because you're studying it for the first time, no? Go through it again. Go through the videos again if you want. Don't worry about the views. Go through this concept again, and I'm sure you will be able to memorize it. This is a new concept. I have given you examples for each and every point over here. Go through the video again. Try to go through the concept again. It's a new concept. You may have to go through the video 2 times to, retain it better. But the more you read, the more you learn, the better you will get. So concept is actually very easy. Take the help of examples. I have highlighted the keywords. Like in this case, writing was important. Here also a few examples. The examples are important in this case. Assignment, we discussed the examples separately. Estoppel, I first explained the meaning of estoppel and then we discussed the example. So go through the video again. Try to learn this concept. And only then we will proceed to the next concept. After we discuss the last part, I think this is the last part. We will complete unit 2 also. Then it is time for test. So please start preparing. Unit 1A, 1B and Unit 2. I told you after every 2 units we will be taking one class test. So start preparing for the test. I will be very soon sharing the test paper with you. Test paper will be shared on the Google Drive link that you had received. You must have received the software, etc. In the same Drive link, I will upload the test papers. So you have to solve the test papers. But for that, you need to learn. Na? So start learning my textbook. Write and practice. Go through the compiler questions. Start preparing for the test. After this concept, we will be conducting the test. You will write at home only. It will not be a live test. Whenever you are ready, you will appear for the test. There is also going to be a discussion video discussing the test paper and the solution. But you can also send it to us for checking. And please attempt the test papers. It is very important. Only then you will be able to gain confidence in this subject. All right, students. So with this, I take your leave. In my next session, I will start the concept of validity of agreements without consideration, section 25. Very important for exam, very important for theory as well as case-based questions. I'll see you there.